Good morning. Hey, it's Bernard Nomberg, Nomberg Law Firm, back on another Tuesday to talk about the law. I've got my buddy Arnold here. Alan, appreciate you coming on.
Hi, everybody.
And today we're going to talk about various topics within employment law. And that's one of the specialties that Alan handles. Alan, if you would, just tell us a little bit about yourself and your firm, and then let's go.
I've been practicing law for 13 years now. I have almost exclusively practiced labor and employment law my whole career. That governs the Fair Labor Standards Act for overtime wages and minimum wage compensation, the Title VII of the Civil Rights Act that protects you from discrimination based on your race, sex, religion, or national origin, the Age Discrimination and Employment Act, and the Americans with Disabilities Act. We also cover things like the Family Medical Leave Act, and we have two retaliatory discharge statutes in Alabama for jury duty. Your employer can't fire you because you miss work to serve on a jury, and they can't fire you if you file a claim for workers' compensation benefits or have an on-the-job injury.
Before we get into those details, and we'll get into that, let's talk about the 5 Points Law Group and your partners, and tell us a little bit about them.
Well, we're very excited about 5 Points Law Group. It's a new firm. We were formed in May of this year. We work with Cara Fontenot and myself, do labor and employment law. We have Burton Dunn, who does conservatorships and elder care issues. And we have Kristen Sullivan, who does wills, trusts, estates, and probate matters. And then we have Heather Fan, who helps with family law for those who are having a hard time with their family life.
And I know most of the lawyers in this firm, and they're not new lawyers. It's just a new firm. They're very experienced, and they really know what they're doing. Alan, let's go into the area of the fact that most Alabamians who are employed are at will. And what does that mean? What does at will mean?
Well, the simple answer is it means an employer can terminate your employment at any time for any reason. It also means you can quit at any time for any reason. But any reason really does mean any reason, unless there are the exceptions that come in the laws I practice in for employment law. Those are exceptions to that doctrine, where they cannot fire you for they can't discriminate against you. If they fire you because of your race or because you're a woman or you are exposed to a hostile environment and you complain about that, that is the exception to at-will employment, and that's what we help people with.
This may be a crazy example, but if today is blue shirt, solid color blue shirt day, and somebody walks in and they're wearing a yellow striped shirt, is that a terminable reason?
Under the at-will doctrine, it would be. But let's say you walk in with the striped shirt and a lady walks in with the striped shirt and the woman is fired and you're not. That might be a pretty good example of sex or gender discrimination. And that's what we could help you with, because then they'd have to explain why you're being treated differently.
Okay. Let's I know you guys that, at least in part, unemployment claims kind of tag along with a lot of the claims that you're looking at. Let's go into that for just a minute. How does one apply for unemployment, and when should you not file for unemployment, and those kind of things?
Well, generally filing for unemployment it consists of going to the Alabama Department of Labor website and calling the 1-800 number and initiating a claim. It's a fairly simple process, albeit it takes a while for a claim to ever come through. However, before you file a claim, if you think for some reason your termination or the end of your employment was illegal or wasn't right, you should consult an attorney first. One of the loopholes in the law that favors employers is that if you file for unemployment compensation benefits and the company opposes you and has a hearing about why you were legally fired, and they win the hearing, the employer does, your claims under most of the other statutes that I help people with go away, because a judge or a court, even though it's not one appointed by the President of the United States, it's just an administrative law judge at the Unemployment Department of Labor, they can't contradict each other. And if they decide you're fired legally at the Alabama Department of Labor, no judge can overrule that. And that's why you should check with an attorney prior to filing your unemployment to protect your rights, because the potential of your lawsuit could exceed the value of your unemployment claim, and you don't want to hurt your potential for a case. It's always a sad day when I have to tell somebody, you've got a case, but because of the unemployment. It's always disappointing. So check with an attorney first, quickly right after you're terminated, because you do need those benefits. You've got a family to feed, but you also still need to make sure you're not losing something in the process.
What about in the and that's all great advice, and I think that's well founded, and it's very important for folks to know this. What about those folks who are still employed with the company? They feel like they're in hot water, or they've been told they're in hot water, so to speak, and they get called in by management for a meeting. A lot of times we've been asked by our clients, can I record the conversation? What kind of advice do you have for folks about that?
In Alabama, you are permitted to record a conversation that you are a part of. That doesn't mean you get to leave your cell phone in the manager's office and record two people talking about it. It means when you're being part of a conversation there, you think you're going to be in hot water, don't hesitate to turn on your smartphone and record the conversation. You do not have to let them know you're doing it. And that is a great way to protect yourself and your rights, and for everybody to have an accurate memory of what actually happened. Many times I like to say that everyone's telling their own truth, and a recording takes that problem out of the equation and can be very helpful in a wrongful termination suit, because then there is no dispute about what was said during those meetings for discipline or termination.
All right, let's and then again, solid advice. Let's say that in this scenario, somebody has gone in and met with their manager, and the manager says, we have to let you go for whatever reason. And now you're terminated, you're no longer an employee, and you're escorted out of the building. But now you think you've got some type of legal grounds to pursue, and somebody wants to come in and meet with you about their potential case. What types of things should they bring to the meeting? What type of information should they have, paperwork-wise or whatever, when they come into that first consultation with you?
For an initial consultation, things that are helpful are any pay stubs you have. They tell us so much information. They can help us. The first thing people ask us a lot of times is, how much is your case worth? I will never know the answer till I look at your pay stub. It's all based on your wages, and it's not an arbitrary number, which sometimes we do see that on TV, and even the numbers on TV are based on the person and their numbers and their payroll and how that's done. Plus, it will tell us where to send the lawsuit. Other information that's helpful. If it's a workers' comp claim, where if you think you're fired because you filed a workers' comp claim, bring us the paperwork for the report of injury. Bring us any disciplinary notices that your employer gave you ever, both before and after the injury. If you have performance evaluations in your possession, bring those. Any document that really has to do with your performance or your workplace, good or bad, helps us evaluate your case. The primary thing to bring also that's helpful are handbooks and policies. It is very helpful in any sort of wrongful termination case to show that the employer didn't follow its own rules that set out for you. But what helps us as attorneys to bring your case is to be able to allege from the beginning they broke their own rules. But we need to know those rules first.
It is pretty incredible how often you see that, where you get the handbook and you're going through discovery and depositions, and the managers just don't know what the policies and procedures are, and they just follow their own way of doing things.
Yes.
So it is, those handbooks can be great information to help with your lawyer. Let's talk about if you feel like you're having issues at work, but you're still employed and you're still going to the job and you're doing your work, but you've got a manager or supervisor, coworker who's giving you fits, whatever it may be. What are your thoughts about keeping a diary?
My thoughts about keeping a diary are, if you're going to do it, at the top of the diary, put in there, for my potential lawyer or my existing lawyer, on the top of each and every page. That means what you're writing is done in anticipation of litigation. And that protects that diary for either an existing lawyer or a future lawyer because you're thinking about protecting your legal rights. A diary that you keep independent or without maybe that little bit of protection could potentially be brought out in the discovery of a case. And from experience, I can tell you, diaries never make the employee look good in front of a judge or a jury because you're putting your thoughts and your feelings in, sometimes just so you can get them out of your head, but they're not things you necessarily need to share with 12 strangers, a court reporter, a judge, and a deputy clerk.
Right.
And especially not the employer you're suing, who's going to try and make hay of it. So just putting that little bit at the top, cover of a diary that says, "For my attorney," helps a ton, because if there's ever a hearing on the issue, the judge is going to sit there and look. They're taking steps to protect this as privileged information. Absolutely, that is the way to go about that.
Do folks who think that they have a claim for discrimination, they can't just file a lawsuit in federal court, can they?
For the most part, no. There are a few exceptions, but primarily almost every discrimination claim for race, gender, religion, national origin, age, or disability all have to go through the Equal Employment Opportunity Commission. It's essentially the first step in the process, and it's not a bad process, but it does take time, and you have to kind of walk your way through it before you get what's called a dismissal and notice of right to sue. That process is important, though. A lot of people go and file a charge on their own or go straight to the EEOC of their own volition. I admit, being an attorney who practices in this area, strongly advise against that. The commission means well. It really does. And I've got good things to say about many of the investigators here in Birmingham and down in Mobile and Biloxi. But they have a process they have to follow. And that process sometimes comes from Washington at a slower pace than the pace of cases handed down by the Supreme Court or the 11th Circuit Court of Appeals. It very much helps if a lawyer helps you draft your charge and make sure certain things are stated so they're clear, because a big argument an employer will like to make is, well, you didn't bring it up the first time, so the issue is waived. And that isn't true. It's because the investigator who took in your intake form without the help of a lawyer doesn't read those opinions, doesn't think about those issues, and you could put yourself in a position where you forgot a potential claim, or your claim may not succeed because you left out some information. And so I strongly advise talking to an attorney about any discrimination claim. Our firm does that every day. We talk to probably 25 to 75 people every day to help kind of go through the process of figuring out, making sure if we can bring a charge, we've made sure everything we can is done to try and make sure your discrimination case has the best chance of succeeding.
And if folks want to get in touch with you about these types of cases, how can they reach you?
We have our website, www.fivepointslaw.com.
And is that the number 5 or the spelling it out?
That is the number 5.
Okay.
And we also have www.fontenottearnold.com. And on that page, you'll see a little more variety about the various areas we can help you with. There's several pages on each sort of category. For example, I spend a lot of my time on cases with the Family and Medical Leave Act, which is a highly regulatory technical law, and we'll, in our intake forms and our process, we'll make sure we find those things. Or if you think you're about to take family medical leave, make sure you find the forms your employer should be giving you. A lot of times employers skip the process because they're going to give you FMLA anyway, and they don't dot all the I's and cross all the T's. But then if they let you go either during or right after that leave, those mistakes can help you with a case. But you can also reach us at 205-252-1550, or Google our name, and any one of our potential numbers will pop up that will get you straight to us and to our staff, which will help initiate the beginning of your case through an intake form.
Well, and this is all very informative information about employment law. I sure appreciate you sharing your expertise and wisdom in these areas. Guys, I think that'll conclude us for today. Alan, again, I appreciate you coming on with us and sharing your knowledge. We'll be back again next Tuesday on another area of the law. Of course, you can always reach me at NOMBERGLAW.com. Our number is 205-930-6900. We hope you have a good rest of your